Hi, my name's Heather Ward. I am an associate attorney here at the Legacy Legal Team. I primarily focus my practice area on estate planning and elder law, mostly estate planning. And today we are going to learn about estate planning with blended families. So, this is something that I have seen popping up more and more often in practice. And it's when, husband and wife are coming in, it's maybe their second marriage or they have children from previous relationships, and it really brings with it its own host of considerations that the typical family unit doesn't really have to worry about. And so it's really important that you've thought about a lot of this stuff before you go in to talk to an attorney about estate planning, but also it's important to make sure you are candid with your attorney about. It can really bring up a lot of emotions for everybody involved, not just the husband and wife. You have some people that might get their feelings hurt, or you're just really wanting to make sure that it's clear what you want to happen and when. So I'll start out by saying, like, really, what would happen with no estate plan, no documents in place, may not be what most people want to happen, especially in a blended family situation. Under statutes about what happens to your things when you die, it's going to go to your spouse. And if you have minor children, it's going to go to them. So that might be joint children. It might be not joint children. Same thing with, like, medical decisions. That can be one part of what we talk about as advanced directives. For medical decisions, the spouse is always going to have the first say in what happens medically to the other spouse, but that may not be what you want. You might have an adult daughter who is, and you'd want her to make that decision instead because she's known you longer. She's been in your life for 35 years. Your husband, your new husband's been in your life for 5 years. You still love him, but your daughter more so knows what you would want in certain situations. So those are just kind of some things to think about. What happens by the law may not be what you want. So the first step in doing all of this is to really just sit down and think about who the key players are. So you have spouse one, spouse two. Cool. Quick and easy to figure out. But then you're going to start thinking about, okay, do we have joint children? Do we have children from prior relationships? Does one of us have a child from a previous relationship that we need to make sure we talk about? Whether or not they have a good relationship with the step parent. Another thing to think about is your ex-spouses or partners, especially if you have minor children with that person, because you might have different things that you want to happen. If, God forbid, you pass away, you might want your minor child money to be managed by somebody else besides that ex-spouse or partner. So really, you've got to think about everybody that's involved, spouses, children, joint and step, anybody that's going to be involved in that. And then you're going to want to think about the relationships with those people. You might be close to your stepchildren, but not to your biological children. And it's just really important that we, as the attorney that's helping you with this situation, that we know that, because we can make assumptions all day, but it may not be right because it's different from every family. What we say is the normal thing to do may not make any sense for your family. Another thing to really think about is, potential conflict. You might have that daughter who is 35 years old, so she's been in your life for 35 years, and the husband's only been in your life for 5 years. She might be upset that you decided to give everything to that spouse and she's not going to get anything. Now, I'm not saying that's not a reason not to give everything to your spouse, but it's something to consider and that we'll talk about. The number one thing that's going to come into play with blended families and planning is that you're communicating openly with each other, with your family, with your attorney. We have had in the past, spouses, they get married later in life. They are a little bit more worried about perking up and saying, you know what? I love you, but I want my children to get my half of things. So it's just really something that you're going to want to be proactively discussing. And then we, as the attorney, can really kind of walk you through. We'll say, like, these are the things that we think you should talk about. I can be kind of an impartial third party and look at that and say, I hear what you're saying. Maybe this is a good solution for you guys. So I want to kind of talk about the easy thing first, which is, powers of attorney and advanced directives. So these are documents that you put into place that say, if I'm unable to make my own decisions, who can make these decisions on my behalf? So this is for your financial, banking, property, and then, of course, medical. So like I said, under Florida statute, the spouse is always going to be making that decision unless there is a document otherwise. So it's really important that you get what we call a designation of healthcare surrogate that says, this is the order of people that are going to make my medical decisions for me. Same thing with a power of attorney. You may not want your new spouse to be able to have the power to give away your property, to empty out your accounts, to do all of these things. Because a real big consideration that you're going to have going into this planning is whether you have kept your property separate. So, kind of like a yours, mine, and ours situation, or whether you have started adding each other as joint owners on things. So that's going to be another really big thing to think about. So obviously, advanced directives, powers of attorney, those are a little bit more easy to talk about, wrap your head around, because you're just picking a person to make decisions for you if you're not able to. Where the bulk of the discussion is going to be is talking about what happens when you pass away. So we, of course, are going to recommend that you either do a will or a revocable trust. You do a will, there's some other tactics that we recommend with that. But I'm mainly going to be talking about in the context of a trust because that's typically what we're recommending for blended families. And it's because we can be very specific about what happens, when, and who gets what. With a trust, we have kind of different ways that we can set it up. We can set up multiple trusts. Like I said, we can do like a yours, mine, and our trust. So there's 3 separate trusts. Or we can set up a joint trust that essentially does the same thing, but it's all under the same named trust. We can say, for example, one thing that is really important to people in a blended family situation is who can be in charge of my things. So when I pass away, sure, I'm fine if my spouse gets things, but I want to make sure that that money's managed properly and that he's not just going to go blow it all or give it to his new girlfriend. So what we see happen a lot is that in a blended family situation, say husband's passed away, husband's daughter then will step in as the co-trustee with wife so that his family's interest is represented along with her. So that's just one thing that we really put into a trust. Another thing, and I see Meredith bringing this up in the comment, she said, how can I make sure that I leave something for my kids in my blended family only after my spouse dies? So that's another consideration. Do you want everything to go to your spouse? Or at your death, so say wife passes away, does wife want husband to get 50% and then her children to get 50%? And another what if to that is, what if we have our own children and then we have stepchildren and then we have joint children? Are we going to treat all of those children the same so that, when both of us pass away, husband and wife pass away, do we want that husband has 3 kids, wife has 1 kid? They don't have any joint kids in this situation. Do we want all of the money to be split up 4 ways so that his 3 kids get a quarter and the wife, daughter, or child get 25%? Or do we want 50%, the husband's 50%, to be split 3 ways between his kids, and then wife's daughter gets a full 50%? This is where we come into the discussion of like fairness and equity. Do we want to make it equal all the way across? Or do we want to make it more equal in terms of, where those children are in life? Maybe one of them has like a really awesome career where they're making a ton of money and the other one's a stay-at-home mom, and we want to make sure that the grandkids are taken care of. There's just a lot that goes into this planning. It's so nuanced just based on family dynamics, how many people are involved, and the relationships with them. Because, you might have your own daughter that you're not close with. You might be closer to your stepchildren. It's just, there's a whole lot that can be done. With the trust, back to Meredith's question, we can structure it to where we leave a certain amount for the surviving spouse. Or we can put what's called a power of appointment, where the surviving spouse is in charge of a certain amount of money and dictates who that goes to. We really can do just about anything you'd want to do. Another added benefit with a trust is that we can do some additional tax planning if that's necessary for your family, for the marital deduction and those things. Right now, the majority of our clients aren't in what I call estate tax land, because for a married couple, it's at about $36 million right now. That number is set to go down next year. We don't know where, so we're kind of getting into the groove of planning for that in case we need to. But again, most people right now, that's not an issue, but that's an added benefit of going the trust route. Excuse me. Let me see. Does anybody else have any questions before I move to talk more about the trust. Right. So with the trust, there's a bunch of different things that you're going to want to consider. First of which is the trustee. Who is going to be in charge of things, both while we're alive, both of us, when one of us passes, and then when both of us are gone. Like I said, sometime or most of the time, if we're doing a joint trust, they're going to want husband and wife to be in charge together, both make whatever decisions together. And then when one of them passes is when the issue really comes up. So in a normal relationship, quote unquote, typically it's the surviving spouse gets to control whatever. They get to do whatever they want. They can wipe out the money. They can save the money for their kids, do whatever they want to do. But with blended families, like I said, a lot of the time they are going to want to name somebody to represent their interests, I guess is the easiest way to understand it. So if husband passes, husband's daughter then steps in and becomes co-trustee with wife, or vice versa. And then, when wife passes, then one of wife's children steps in and then they are co-trustees. Or at that point, then we can appoint all of the kids. Like if there was a stepchild from each side and then a joint children, then maybe we do a panel of 3. We can really do whatever you are comfortable with. We get hesitant to add too many people into the pot because then it gets hard to make a decision. And then we end up in court and nobody wants to do that because then we're spending trust money so your trustee is going to be a big decision. Then the next decision is going to be, okay, when does everybody get something? Does spouse get everything and then whatever's left over goes to the kids? Or do we want to split it into yours, mine, and ours? We can, again, do whatever percentages at whatever times you want to do. And then, of course, as with any trust, you're going to decide when somebody gets something, how they're going to get it. So we can put whatever limitations you want about how that money is going to be spent. So if, for example, you only want the surviving spouse to have money for, typically the standard is health, education, maintenance, or support. So if you want them to be able to use it, if God forbid they get cancer, you say, yes, absolutely, I'd rather them get cancer treatment than my kids to inherit money. I recently had a client who they started out by saying, no, I only want this to be for health. Otherwise, everything's going to go to my kids. And then the more that they thought about it, they're like, well, actually, I think my kids would, they like their stepmom. We want them to, they'd want her to use the money for anything that's going to be beneficial to her. But then we include language that says the trustee doesn't give that money out without first examining her own asset. So she can't just wife can't just go and use all deceased husband's assets to do her own housing or whatever. But if she doesn't have another income because or doesn't have enough income because she's retired or disabled or doing things that she would normally do, then they can use the deceased spouse's assets. And that's in the trustee's discretion. And we can make it as flexible or as strict as you want to. But yeah, I mean, that's really the bulk of things that you're going to want to think about before you come and talk to an attorney. Of course, your attorney is a professional who is going to help walk you through all of this during your initial meeting and then through the planning and review stages of setting up an estate plan. A trust may not be what you want. Just because you have a blended family doesn't mean you have to have a trust. But we'll talk through those options with you. That's why it's important to work with an attorney that you trust and that you feel like you can have more of a personal relationship with, because I mean, some of the stuff is hard to talk about. We will insist that you guys talk to us together. If one of you comes after the meeting and says, hey, I didn't want to say this with my husband in the room, but I actually have this kid he doesn't know about, and I want to make sure we talk about that in the documents and hide that from him, where I'm able to represent you at that point. So again, it's really important to be open paths of communications with each other, with your family, with your attorney. And we help you get through all of that together. So I will stay on for a couple more minutes. If anybody has any questions about this, about estate planning in general, or even about another area of the law, I can try to help. If I can't answer it, then somebody else will pop on at some point and respond to your comments. And then, of course, if you want to reach out to us directly, you can give us a call. The number is 352-394-7408. And you can get on the schedule to meet with any of our attorneys. If you do decide that you want to work with us for estate planning, you'll be able to meet with me for free to talk through your options, and then we'll give you pricing and on from there. Random I see that you have given us a comment that is not in my practice area, so I will make sure that somebody gets back to you on that. Likely will be Meredith. I don't know if she's still on and can respond, but at some point she will. So I have a comment saying, does it make sense to make an estate plan now in my 30s, hoping that I won't pass until my 80s? Yes. So I'm in the same situation. I am engaged, but I'm not married yet. So that's especially important for me because I do have certain things that I want to happen with my assets. And also, especially important for me, my parents are divorced. So if I were to die right now with nothing in place, which I'm an estate planning attorney and don't have an estate plan, so that's an issue. But if I were to pass right now, like 50% of my stuff would go to my mom and 50% would go to my dad. My fiance, who I've been with for 8 years, would get nothing, including my dog, who's been with us the whole time. So yeah, it's really important, especially when you're young, to get estate planning done if you don't want the normal things to happen. And especially important for like advanced directives. You might have, somebody that you're close to who has the same beliefs as you with end of life decisions. Your mom might never want to pull that plug, but your best friend would do what you want to do. So that's really important when it comes to stuff like that. You know, it really is also going to depend on what types of assets you have. I might recommend a trust. A lot of younger people that don't have minor children, I'm not going to recommend a trust to. But if you have very specific things that you want to happen, or you have a lot of certain types of assets, then we might go that route. But of course, that's something that your attorney can walk through with you to make sure that we're doing a custom plan for you, that your situation. Stay on for a couple more minutes, see if anyone else gets back to us. If it hasn't been posted yet, there is a blog post coming on our website on this topic. So if you want to like refresher, you'll be able to read through that. And then of course, give us a call if you have any further questions. Yeah, I think that's going to be it for today. It's been great talking to you all. I hope that you got to catch it live. If not, you'll see this recorded and posted on our Facebook. I hope to hear back from some of you, and let's get your estate plans going. Have a good rest of your day.